Presidential Election Petition Court, sitting in Abuja, delivered its eagerly awaited judgment on Wednesday, September the 6th, 2023, affirming the victory of President Bola Tinubu in the February 2023 elections. And since the ruling was delivered, some members of the bar have reacted, commending the judges for putting in serious work in the jurisprudence and philosophies underlying the decisions. This was, however, unflattering for men of the inner bar who led the team of the petitioners, that's the Labour Party and the PDP, who were reprimanded for preparing their cases in a hurry. This has drawn from the position of the judge's ruling that the petitioners made generic allegations without providing specifics. Let's explore the high points and lessons of the September 11 ruling with another member of the inner bar, as I bid you welcome to Hard Copy. I am Bukola Koka, standing in for your regular anchor, Maokwe Ogun Yusuf. Stay with us. We'll be right back. Mr. Adegboruwa, Senior Advocate of Nigeria, welcome to Hard Copy.
Thank you for having me.
Yes, indeed. Thank you very much for this time. So, we're starting off with a review, and perhaps we can draw some lessons from the rulings of the Presidential Election Petition Tribunal. So this has elicited quite a number of reactions, on both sides of the divide, some for and some against, with some saying that the case of the petitioners was ill-prepared. Do you agree?
When you say you want to evaluate the judgment of a court to determine whether justice has been done or is been seen to have been done, a lot of factors will come into play. The role of lawyers, the role of the judges, the nature of the evidence available, the time frame within which all parties worked to achieve the result. And then, of course, it will also depend on the nature of the subject matter of the case. In this particular case, that is the petitions presented by Labour Party and the People's Democratic Party, and indeed APM, you will see that lawyers were involved, close to 120 senior advocates and other colleagues from the outer bar. Parties were involved, the People's Democratic Party, the Labour Party, and then judges were involved, 5 justices of the Court of Appeal, all experienced people who have risen through the ranks, most who started from the magistrate to the High Court, and then they got to the Court of Appeal. And then you look at the nature of the evidence. We are reviewing results from about 186,000 polling units. We are reviewing conduct of election in about 774 local governments, and then a volatile matter that started from the campaign period up to the election and indeed after the election. And then you then consider the role of the nature of the time available to do all this. From the period of the election in February, according to our laws, it must conclude within 6 months. So you see that the nature of the judgment itself will be affected by these factors. In this particular case, even to deliver the judgment took close to 12 hours. Mm-hmm. Everybody was glued to their television all over the world, listening to their lordships, bringing out the facts and their decision on those facts. So for me, Nigerians should commend, first of all, the parties. In some other clime, when elections become so tense, in the nature of what we had close to the February presidential elections, you usually have violence, disruptions. I want to commend all the players, the stakeholders, the people who won, those who lost, and then the lawyers advising them.
Indeed. Many, in fact, believe that it is even disappointing, particularly because senior lawyers, senior advocates of Nigeria led, the defense of these cases. And some junior lawyers are saying that senior advocates do not read the case and they leave the studying of the case to junior lawyers in their chambers. Is this true?
Well, let me just say that we need to appeal to our leaders, especially those who desire to hold political office, to embrace the practice in other jurisdictions where democracy is practiced. And that is to say that I do not think that is every loss that should be a subject matter of litigation. As a lawyer, I should be happy that litigants prefer to go to court on every issue. But we must put the interests of our nation above our personal interests. The issues surrounding leadership recruitment in Nigeria generally require holistic examination. Because for those who put themselves up to offer service to their nation, the primary consideration should be that nation that you want to serve. So if for one circumstance or the other, you are unable to attain that objective, perhaps there should be another goal. I don't see it as something that should be a do or die. In other words, once I lose, no matter the circumstance, no matter the objectivity of the umpire or indeed the parameters of the exercise, I must just contest it. I think that we have to find a way to mellow the expectation of the political players to ensure that in most cases, it is not every electoral loss that will result into litigation. Now, in this particular case, I have maintained that it will take a miracle in the present circumstance of the existing laws of Nigeria to upturn a presidential election. And I say so with all respect to all my colleagues and the lawyers, because you look at the conditions for doing that, you have to place yourself in a position to be able to analyze the materials used by INEC, and in this case, the results. In this case, the conduct of the election itself at the polling units. If you say, for instance, that you are the highest scorer in the election, or that you got the highest votes, you have to supply materials that will show how you did that. Then you go around all the polling units, you go around all the local governments, you bring all your agents. So you can imagine in that kind of election, it will require that we're going to call about 186 witnesses from all the polling units. 166,000 witnesses from all the polling units. We're going to tender all the election results. Assuming you even do that, would the judges have the capacity and the time to be able to go through it and come up with a credible conclusion in respect of that? Do you have experts who would go through this and then come to court and be able to demonstrate it? The time regulating election petitions gives a limited time frame within which this should be done, and understandably, because we have to talk about public office. I mean, you wouldn't want the winner of the election to continue to enjoy the tenure, and then it takes so long for you to determine the petition. So it was a common agreement within the legal profession and indeed in Nigeria that we should shorten the period of election petitions so that the people will be able to know their fate ahead of time. So in this particular case, I cannot say that the case was ill-prepared. I say that there was no time. I say that the law existing now makes it difficult for you to, even where you have a good case, to present or prosecute it. So I will say that both for the lawyers and for the parties, it was difficult for them to have upturned the election.
Now, on other issues, as we begin to look at the rulings of the justices one after the other, many have quoted as less than perfect the position of the justices on the issue of non-compliance of the INEC, with transmission of results to the IREV portal, citing that the law does not mandate INEC, on electronic transmission of results via the IREV portal. In fact, one of the justices said the IREV portal is not a collation center. Is this a technicality?
Once an election is declared by INEC, to say, for instance, I have won an election, and there's a declaration made by INEC, the law takes it that that is the position. It is a person who is challenging that declaration that has the onus to come and show that that declaration is faulty, is wrong, or it constitutes falsification or misrepresentation or manipulation. And for you to do that, you first of all need to get what INEC has declared. you need to get to the basis of the documents that INEC relied upon to make its declaration. So that means you need the certified true copy of the results declared by INEC itself. Because you want to upstage that, you have to bring that to the court first, because that is what INEC has relied upon. And you have to impeach that document in order for you to succeed to upturn the declaration. And that's the point that I'm making. For there to be election results, I mean, it is a document that INEC produced and fill in certain information on that form. At the period of collation, party agents are supposed to be available to be able to sit down to confirm the number of people who voted and then authenticate the results. And then parties are given copies. And then INEC takes the original back to its base for collation. So if you want to upstage that result, for instance, the one you have must be the same as the one INEC has. So before you say the one INEC has is not the same, you must bring the one INEC has first, which is and it must be certified from the custody of INEC. So it is the INEC's document that you bring to the court to use your own to challenge it or to upturn it. And the point I'm making is that for you to bring that document of INEC, you have to go through the 186,000 polling units and bring the one INEC has. It may be wrong, it may be false, but you have to bring it to the court first. And then one by one, you'll be bringing your own to juxtapose and show the difference for you to be able to go through it one by one and convince the judges that indeed there was manipulation. So in limited elections, maybe for instance, House of Assembly, which is just about 200,000 voters and maybe about 10 polling units, you've seen that such results have been upturned in many cases because it's easier, I mean, to be able to collate such results because it's within a limited scope. So the point I'm making is that for you to do it for a presidential election, you need more time, because the same time that House of Assembly members deploy in upturning the election cannot be sufficient for the presidential election because it covers the entire nation. You know, and that's the challenge that people have. The policy of election petition is this. The law takes it that what INEC has done is substantially correct.
Is the authentic?
Yes. So for you to upturn it, you must upturn it to a certain degree that is so prevalent, that is so major. Maybe, for instance, 90%.
90%?
Against what? Yes. So if you are only able to do 10%, if you are only able to do 5%, probably they will tell you that it's not substantial or sufficient to nullify the election.
The entire
oh, yes. So it's not that every infraction that, maybe for instance in Lagos, where there was said to have been a lady who was stopped from, prevented from voting, or that was beaten up or injured. If you present only that case for Lagos State, the judges will tell you that it's not sufficient to overturn the elections from all the other 20 local governments. So the point I'm making is that those infractions have to be substantial and cut across virtually a majority of the areas in Nigeria for you to say that the election was not properly conducted.
Still, many feel hard done by, particularly young people who took responsibility for their electoral future through the 2023 February presidential election, many of whom monitored their election at their polling units, who took pictures of the results sheets from the polling units where they voted. And they're in fact saying that what the justices ruled on was not particularly what transpired during the proceedings based on evidence that would have been presented by witnesses, i.e. party agents of the petitioners. Shouldn't that, if it was able to create reasonable doubt, have been considered by the justices and by extension required INEC, to be accountable based on what it promised, that it would transmit results electronically to the IRF portal?
My own personal position has been, and it is still, that the judiciary should use the opportunity of the election petitions being presented to assist Nigeria. And I say that with all respect to their lordships. What I mean by assisting Nigeria is this. So long as our election remains in the realms of manual collation, so long as we have so much of human intervention in the process and management of elections, you will continue to have manipulations. Because it's natural with anybody to seek to upstage the system. And Nigeria's experience has always been that politicians are very desperate. So when we were advocating for a reform of the electoral regime, was that we wanted less of human intervention.
As we custom gradually, let's look at the ruling of the justices on what seems to be a matter of continuing debates now, the status of Abuja. Could the justices have been clearer rather than say that Abuja does not have any special status? Or for the purpose of future elections, would we be requiring an amendment to the laws, just for clarity's purpose?
The decision of their lordship in respect of the status of the FCT is to equate the Federal Capital Territory as a state for the purpose of election, for the purpose of determining presidential election, that the FCT is enjoying the same status as a state. So it's not required, for instance, that a person should win, 25% or score 25% votes in Abuja before he's declared president. That's their decision. I agree with that decision, and I'll tell you why. I live in Lagos State. I don't see any reason why voters in Abuja should enjoy superiority over those who vote in Lagos. Because Section 42 of our Constitution says that do not discriminate against me by circumstances of my birth, by circumstances of my geographical location or my conviction. So if I was born in Ondo State and I want to vote there, there's no reason why you say if people of Ondo State votes for me and gives me 25%, and then those in Abuja fails to give me 25%, then I cannot win the election. And then the rest of Nigeria, Ondo, Ogun, Akwa Ibom, Oyo, everywhere, Kaduna, and they elect a person, and you say because those in Abuja fail to give him their mandate, it will be equating voters in Abuja with a superiority status, But for me, if that is the purpose of those who wrote the Constitution, it should be made clear. But as it is presently, Abuja enjoys the status of a state. But for me, generally, the election and the election petition presents an opportunity for us to look at INEC. And I think that's my own point, because we will come back to this in another 4 years unless we look at INEC and look at our laws. How do we unbundle INEC? We give INEC too many things to do. Audit the finances of political parties, monitor all primary elections, and then conduct elections, conduct voters registration, register political parties. That can happen. There's no way a single organization can do all this and they still have the opportunity to present a credible election. So we should separate the functions and create institutions. Let's have another institution who will conduct voters register and determine the voters cards of people. Another institution who will be responsible for monitoring political parties. The one conducting the election should be limited to the conduct of elections, so that INEC can have the opportunity and time to be able to present an election that is credible, that is free, and indeed that is as satisfactory to all the people of Nigeria. The way INEC is now, if you keep conducting elections in the next 4 years, 8 years, we'll still be coming back with the same results.
And lastly, or two more questions before we go, the petitioners have resolved to head upstairs, as we say, to the Supreme Court. But some members of the bar, your colleagues, say that the law is a prophecy of what the court says. So is this another wild goose chase, or should we, by any shred of optimism, hope for something different?
I think for us, maybe that's why members of the public seem to be blaming the lawyers. For us within the legal profession, we desire that we should have a process that is so transparent that there will be less litigation. Because the fact that there are so many litigation post-2023 elections shows that there are problems everywhere. I don't want to predict their lordships in the Supreme Court, but those of us within the legal profession can tell you that we already know what the outcome of that exercise will be. But it's good to give people the opportunity, to ventilate their interests. But for me, the judiciary should use the opportunity of these election petitions to correct the anomalies, to highlight the errors, so that even the legislature can take hold of their judgment and go back and amend the Electoral Act. So it's not just to throw out the cases, because judges make law themselves too. And that's what happens in other jurisdictions. So the judges themselves become lawmakers when they look at the cases, and then they can give, through their ruling and their pronouncement, an opportunity for Nigeria to correct some of those imbalances and get to a regime where our elections can become more predictable, credible, and indeed peaceful.
And that would be no significant change. But yet another opportunity for the senior advocates and their lawyers to smile to the bank, right?
Hey, well, I think that the Liberal deserve his wages.
Yes,
I think so.
And lastly, the states are also awaiting the outcome of the election petition tribunals, and some are saying that there will be upsets. Do you agree? What are your expectations?
Well, like I said, the objective conditions for determining election petitions at the state level, at the senatorial level, at the House of Assembly or House of Rep level are a little bit less burdensome because we now operate within a limited state. The materials you have to examine are lesser. So I won't be surprised, for instance, if there are upsets and that the lawyers and the parties have had enough time to be able to scrutinize those documents of INEC and indeed those of the political parties. So I won't be surprised at all that they may be upset. And my concern is that if we leave the presidential election the way it is now, we'll continue to bounce ourselves back with the same results.
So the real challenge is with the presidential,
election because of the space that you need to cover in order to dislodge a winner in that election. You know that for us, within the legal profession, we take it that if you are aware that I have committed a wrong, you are not allowed to continue to parade that error forever. I must know within myself that you intend to engage me in respect of the wrong they allege against me. If you say I've taken your land illegally, it's expected that within 12 years, you should be able to go to court to challenge me. Because you can't leave me to remain on that land forever. And I've built on it, I've taken, so I'm expecting that nobody is coming to challenge me, so I've invested on it. So they will give you 12 years. If, for instance, I slap you, I mean, it's a case of thought, so we'll give you 3 years to prosecute that. And it's like that in our legal profession generally. Within the period of conducting an election and declaring a person as a winner of a primary, you have 14 days within which to challenge his qualification if he's not qualified to have been paraded or at least elected as a candidate of a political party. If you don't do that, it becomes a matter that is statute bad. For me, the understanding I had from all the cases, APM, PDP, and indeed Labour Party, is that the courts are giving the impression that the issue of locus to complain about the qualification of a candidate belongs to the political party. And I think that's what we are advocating within the legal profession, that we shouldn't give it to everybody to come to say, maybe, for instance, I'm qualified to represent Nigerian Bar Association in an election. If the NBA deems it fit to parade me as their candidate for any election, it should be the business of NBA. The issue of the statute of limitation in respect of the forfeiture is a constitutional requirement, that is placed there by the Constitution to say, if you are aware that a candidate has been convicted of any offense, that conviction you want to rely upon must have happened within the last 10 years of the period of the election of that particular candidate. So to that extent, I think that there was a unanimity of opinion by their lordships in respect of educational qualification, because indeed we've been saying it that the Constitution imposed illiterates on Nigerians, because all that you require is a school certificate.
Senior Advocate of Nigeria, Mr. Adegboruwa, thank you for coming on Hard Copy.
My pleasure. Thank you very much.
Perhaps the most profound lesson from my conversation with Mr. Adegboruwa is his advocacy for the amendment of our electoral laws, particularly as they relate to the presidential election, and the need for that process to begin and be dispensed with well ahead of the commencement of the election cycle. Still, some of his colleagues will argue that we can't legislate our constitution to perfection. Maybe that's why they're lawyers. That's it on the program today. Thank you for watching. I am Bukola Koka. See you next time.